My name is Thomas Force. We're going to discuss today topic professional courtesy and discounts, what every OMS should know. We're going to be discussing waiving basically patient deductibles and coinsurance, and exceptions when it's permissible and when it's not. We're going to discuss dangers, compliance dangers for doing that. And I want to go through my this is a little briefing about me. Here's the agenda. We're going to talk about general considerations and provider challenges with respect to patient cost share, ensuring billing of patient cost share. We're going to discuss the False Claim Act and anti-kickback statutes on both the federal side, federal law, and state law, statutes and state law that mirror these. We're going to discuss waiving patient balances for Medicare and other federal plans. We're going to discuss waiving patient balances for commercial plans. We're going to discuss health plan language that you may not realize exists, whether you're in or out of network, with respect to waiving patient balances. So we're going to give you some of that language. We're going to discuss, and I think it's very important to discuss case law, actual cases dealing with so-called fee forgiveness. That's what the insurance carriers call it. They call it fee forgiving. When there's a legitimate coinsurance or deductible owed by the patient and the provider decides to not bill the patient and waive that balance, they call it fee forgiving. We're going to give you the view of fee forgiving from the Office of Inspector General, which monitors and regulates compliance with Medicare, Medicaid, and other federal programs. We're going to give you some exceptions where it's permissible to waive cost share balances that are owed by the patient. And we're going to conclude with some more case law. I want to just stress, in my business, I deal with a lot of medical practices. I own a billing company, I own a revenue company, and I also have a law firm, and we defend audits. I am now currently defending roughly about 10 audits by insurance companies and regulators against healthcare providers who have, most of the time, really not understood but actually waived balances owed by patients. I'm talking about deductibles, coinsurances, and copays that are listed on EOBs that have to be collected. So I have a lot of experience with things, with these type of audits when things go wrong. All right, and I can tell you most of those providers that have done fee forgiving, quote unquote, really didn't realize they did anything wrong. And now they're looking at the potential of having to pay back sometimes upwards. I have a couple of cases upwards of 7 figures to an insurance carrier. I've handled a few Medicare audits of the Office of Inspector General against practices that didn't bill co-payments and coinsurance and deductibles as well. So I hope this is very valuable. At the end of this presentation, I will have questions and answers. I also encourage you, if you don't want to ask a question or an answer, email the American Association of Oral and Maxillofacial Surgeons, or email me. My email address will be in these slides. Okay, so financial hardship keeps many patients from seeking medical care, knowing that they will have out-of-pocket expenses. So what happens is healthcare providers often forgive or waive co-payments, coinsurance, and deductibles to assist these patients. In other words, the healthcare providers are trying to do good. They want to do right by their patient. And they're like, what's the harm of doing this? And anyway, whose money is it? Again, it's trying to help your patient. Now, if you're an in-network provider, you're dealing with in-network co-pays. Every time a patient comes to your office and you're a participating provider, right? They're going to have to pay a copay, $25, $20, $50. The deductibles and coinsurance, if you're a participating provider, if you're in network, they're going to be lower. If you're a non-participating provider or you're out of network, those deductibles and coinsurances are a lot higher. And that's why it's more difficult if you're a non-participating out-of-network provider to bill cost share responsibility to patients than it is for an in-network provider. That's not to say that in-network providers don't have a responsibility to bill coinsurance and deductibles. That's not to say that at all. They do. They have that responsibility, just like an out-of-network provider has that responsibility. But for an in-network provider, those cost share responsibilities owed by patients are significantly less. So you're going to see when we review cases, you're going to see a lot more cases filed by insurance companies against out-of-network facilities and medical practices because the cost share responsibilities are higher. And it's more difficult for an out-of-network provider to bill those patients. Again, what does the medical provider want? The medical provider wants to take care of their patients. You know, if the patient, let's say you're out-of-network ambulatory surgery center or a surgeon. In this case, you're doing oral surgery, right? You're out of network and the deductible is $5,000. So the patient says, listen, I'd like to go see you. I like you. I think you're a better surgeon than the in-network provider up the block, but I have to pay a $5,000 deductible if I see you. And if I go to the in-network provider, I'm paying $100 copay. So that's the dilemma that out-of-network providers face. They're afraid if they provide too much disclosure that the patient will have a high cost share responsibility, that patient will go to an in-network provider. And you know, if you're an out-of-network surgeon, oral surgeon, and you provide disclosure that the patient will have to pay essentially more on an out-of-network basis for cost share responsibility than in-network, you're going to lose some patients. Some patients won't be able to afford it and they're going to want to go in network. Okay, so that's the dilemma that the out-of-network provider has that in-network providers don't. And that's why most of the cases that we look at later revolve around out-of-network ambulatory surgery centers, hospitals, and physicians. Again, to highlight, that's not to say that an in-network provider can't get in trouble for waiving deductibles and coinsurances. I see it all the time. They do. I have a provider here in Long Island that has an in-network practice across the street from him. They're both in-network. They both do the same thing. So he decided that to get a competitive edge, he would waive deductibles and coinsurances and copays. So now to the detriment of the practice across the street that's doing things the right way and billing deductibles and coinsurances. He's an in-network provider. He's facing an audit now because apparently the competitor across the street wasn't too happy and whistleblowed to a couple of the insurance carriers. So if you're an in-network provider, this class is important to you as well. My point is that the out-of-network provider, it's more difficult to bill the patients the out-of-network cost share because the cost share is higher. Okay. So here's your first polling question. Which is an example of how health plans limit overutilization of services? And here is the answers. A, requiring member patients to pay their share regardless of whether the provider is in or out of network. B, allowing providers to reduce patient cost share portions. Remember, to limit, what do the carriers want to do to limit overutilization? C, allow professional courtesy to apply only to providers' family members, or all of the above. Hopefully the answer will be pretty obvious in the next couple slides.
And we have 90% of our respondents choosing A for the answer.
Correct. Correct. So health plans will tell you that they want to make sure providers bill for their cost share responsibility, whether you're in or out of network. Why is that? For overutilization of services. If a patient knows that they can go to a provider and not have to pay the $25 deductible or 50% coinsurance, they may utilize those services significantly more than if they had to pay $50 every time they went. I have a pretty good health plan for my employees, and it's in network, but for chiropractic services, it's $75 deductible for each and every time I see the chiropractor. $75. That's almost as if I have no coverage. All right. If I know that I have to pay $75 every time I go get a chiropractic adjustment, I might maybe go twice a month. If I didn't have that $75 cost share responsibility, if let's say the provider waived it, I might go 20 times in a month if my back was hurting me. So that's why these insurance carriers are absolutely adamant that in order to limit overutilization, you need to bill your patients the cost share responsibility. So I mentioned before, a lot of providers tell me, well, like, whose money is it anyway? It's not like I'm collecting the money, I'm waiving it, right? So you have to understand the way the insurance carriers view this, right? So if a balance is owed to the provider, it's the provider's money. So the provider will say, so why should there be any restriction on fee forgiveness or waivers of such balances? It's my money. If it's a $25 copay, I would get the $25. Why can't I waive it? Well, we just talked about overutilization. All right. That's the point of the last polling question. Health plan contracts and network agreements always limit or preclude participating providers from waiving member or patient balances. They preclude, frankly, out-of-network providers as well. So a lot of out-of-network providers will say, hey, wait a minute, I don't have a contract with the insurance company. So I can do whatever I want. Not true. First of all, you probably have an assignment of benefit where you step in the shoes of your patient, which means all the obligations that the patient has under the contract of insurance you have. But as we see later on, there's also some causes of action that that the carriers could sue you for, like tortious interference with their business contract with their member, that you need to be concerned about. So also keep in mind that waiving patient cost share responsibility for federal programs such as Medicare, I would just warn you, be very, very careful. I tell most of my clients, don't waive balances for Medicare and Medicaid and other federal programs. And if you're going to use an exception like financial hardship, document. All right, because the feds take this very seriously. So the main reason why they're pushing the provider to bill cost share responsibility, deductibles, and coinsurance is to limit overutilization of the services. I'll give you a second reason that's not in this PowerPoint. The second reason is really generation of revenue for the administrators. I'm talking about the Aetna's, Cigna, United Healthcare, and the like. They have audit departments where you'll see soon when we go over the contracts that in these audit departments, if they find out that a provider is routinely waiving balances for deductibles and coinsurance, under some of their contracts and policies, they can go back in time and retroactively deny claims. So if they paid over the course of the last several years a provider $2 million, they can recoup that money. So it's become a big money-making revenue scheme for the providers to look for fee forgiveness so that they can retroactively deny claims that they've already paid, take back that money, and not pay future claims. And trust me, I'm handling a bunch of these type of issues right now. And I would implore you that if you're being audited for fee forgiveness, you get a letter that says that the insurance carrier wants to see copies of statements and patient ledgers proving that you billed patients and collected cost share, don't handle it yourself. Call someone like me or a compliance expert or an attorney, because these things could be very, very lucrative for the carriers and really hurt the practice. So again, we're getting back to, the provider saying, well, it's my money anyhow. These are the things that you have to be aware of. And if this course does anything, I'm hoping that it opens the provider's eyes that waiving patient balances could be a costly endeavor, could blow up your practice and subject the practice to criminal and civil liability. So you have to have a game plan and a policy if you're going to waive those balances. Your policy should be, we always collect deductibles and coinsurances from patients. We collect a co-payment up front. We send 3 statements, and we don't write off a balance unless we send 3 statements and make a reasonable effort to collect that balance, unless one of the exceptions falls into play, such as financial hardship. In other words, it's a financial hardship policy. You can waive the balance based on that, or a prompt payment policy, or some of the other policies that we're going to discuss in this program. All right. So you would say, I'm waiving balances. How could this be a false claim? Most providers don't understand this. But when you bill a claim, be it whether you have an in-house billing department or you use an outside billing company, you're representing not the billing company, not your staff. The provider that's the rendering doctor on that claim is representing that claim is accurate and true. Okay, so the insurance carriers and their proxies take the position that if you're going to waive balances, you're committing insurance fraud. And I'm going to give you a couple examples to show that. So the insurance carriers will say that you submitted a false claim. Why is that problematic? Well, under federal law, you have on the right side, you have the False Claim Act to worry about, where financial damages could be in the millions. And you also have federal anti-kickback statutes. On the non-federal side with commercial insurance plans, you have to worry about common law fraud allegations, breach of contract allegations. That's the contract between even if you're out of network, if you're in network, it's your contract that you signed with the insurance company. If you're out of network, it's an implied contract and also a contract by virtue of your member's contract. The last cause of action on the left side, intentional interference with a contract right, that's almost always the first cause of action in these type of fee forgiveness actions. The insurance company says, hey, my contract requires my member to pay their deductible and coinsurance. By you waiving it, you're interfering with our contract with our member, and that's a tort. You can be found liable for civil damages based on any one of these common law fraud, breach of contract, or intentional interference with a contract right. So let's talk about we've talked already about some of the challenges and risks of waiving patient cost share responsibility. So let's talk about carriers, insurers. Whether it's an insurance policy where the insurance company, the Aetna, the United Healthcare, or actually insures the medical benefit, or if it's a self-funded policy where the insurance companies are simply acting as an administrator for the self-funded plan. It doesn't matter. These insurers have implemented at great expense department staff with ex-law enforcement officers and federal and state prosecutors that target and analyze healthcare providers' out-of-network billing practices and in-network practices, by the way. As a result of these initiatives, insurers and plan administrators are refusing to pay claims, heavily discounting those claims, or initiating litigation, usually as a countersuit to a provider's claim for unpaid claims. You'll see later on, a lot of the lawsuits, the provider says, hey, Cigna, you're not paying our claims. We're suing you because you owe us $200 million. And then Cigna countersues and says, yeah, we're not paying your claims because of common law fraud, interference with a contract. you're committing fraud because you're not billing cost share. And our contract clearly says that if you're not billing cost share, not trying to collect it, we don't have to pay your future claims, and we can go back and recover all of that money. And it's a pretty compelling argument. As I state here, second bullet point, unfortunately, many in-house and outsourced billing companies are very unfamiliar with the tactics necessary to navigate reimbursement and patient collections, particularly if your billers only handle in-network. In-network is relatively easy. You're billing a service, it gets paid. You contractually write off the insurance balance, and then you bill the patient for their deductible and co-insurance. Out-of-network, there's no contractual write-offs. So for out-of-network, you're billing a patient, it gets partially paid. There's a huge out-of-network deductible and co-insurance. You might appeal that claim to get a higher reimbursement. You might open a negotiation with the likes of MultiPlan or Mars or one of those companies. And at some point, you're going to be billing the patient for a higher cost share than in-network. So if you're waiving balances and the patient can go to your practice and pay less to see an out-of-network provider than an in-network provider, that's a problem. And the insurance companies are looking for that. And that's about waiving balances. So third bullet point, in this economic environment, healthcare providers are wary of billing patients' cost share responsibility for fear of losing their patients to competitive practices. We talked about a couple examples. This is even more a concern for out-of-network providers. So how they get involved with this is, and I've seen this happen so many times. If the billing or revenue company or in-house people are not sophisticated, a patient will say, hey, I can't afford to pay my $5,000 out-of-network deductible. And the response, which is the incorrect response, is, don't worry, we're not going to hold you to that. We're going to accept insurance as payment in full. Once the insurance carrier finds out about that, you're in a fee forgiveness audit and you're in a lot of trouble. So insurers, as we've discussed, have recently filed numerous counterclaims against healthcare providers for so-called fee forgiveness. They allege tortious interference with a business contract, fraud, and they've had success doing this. Again, provider says, you're not paying me, I'm suing you for $10 million, and the insurance company countersues and said, well, we're not paying you because of fee forgiveness, you committed fraud. And that they say that not only are we not paying your claims, but you owe us all the money we did pay you. So the insurers maintain that it is a misrepresentation to bill the patient an amount that does not relate to what was billed to the insurer, that the actual bill charge is actually what was charged to the patient. You'll see, we'll have some examples of that. I know that's a little confusing. Insurers additionally argue that the health plans require a patient to pay their cost share responsibility, co-pays, deductibles, and co-insurance, and a provider's effort to avoid that liability, that responsibility, renders the claim ineligible for payment and is tantamount to insurance fraud. Now, do I agree with that? No, I argue, I represent practices. I don't represent insurance companies. I don't agree with that, but I'm just telling you what they're arguing. You need to understand the way the health plans and the administrators of these plans and the insurers, how they view waiving balances. So, I did say be careful of waiving balances for Medicare. Medicare generally has a 20% co-insurance, right? And if the patient doesn't have a secondary insurance where the claim crosses over to like an AARP or something like that, you have to bill the 20% co-insurance. And if you waive that balance without falling onto one of the safe harbors or exceptions, you're looking at a potential problem. The feds view waiving of cost share responsibility for patients tantamount to insurance fraud, just like the insurance companies do for non-federal claims. And these are the causes of action that you'll see most frequently when the Office of Inspector General gets involved in these type of cases. And many of these cases are started by whistleblowers. It might be a former employee of your practice, a doctor that's currently at your practice, or a competitor they whistleblow and tell the feds that, hey, they're not billing my coinsurance, they're not billing Medicare coinsurance, and then you're in an audit. So the Federal False Claim Act, right, prohibits knowingly submitting a false claim to the federal government. Again, the government feels if you're submitting a claim and you're not billing the coinsurance, the 20% coinsurance for Medicare, that's a false claim, and the False Claim Act applies, and you'll be sued under the False Claim Act. All right. The thing that's interesting about these, unlike the state causes of action for fraud, that no specific intent to defraud is required. Knowing, in order for the government to prove that the provider committed a false claim for fee forgiveness, they don't have to include actual knowledge, but they can just prove deliberate ignorance or reckless disregard of the truth or falsity. So if you're taking this kind of a course and you take action, that's a good thing. You know, they can't show that there was an intent to defraud the government. So what does the government look for? Do they look to waiving balances for this patient or that patient occasionally, even if there's no reason for it, or you're waiving, you're giving professional courtesy to some doctors or their spouses that work in your facility? They're not looking for that. They're looking for routine and systematic waiver. That's what the insurance company's looking for. That's why they'll ask you for 50 accounts. They want to see your patient statements. They want to know that they want to see that you billed patients multiple times, you've made a good faith attempt to collect, and you've actually collected some of the cost share responsibility. If you for all 50 patients, if you didn't submit any statements or collect anything, that's going to be evidence of routine and systematic waiver of patient responsibility. Okay. The False Claim Act includes not only civil penalties that cost you a lot of money, but criminal penalties. You can actually go to jail for violating a False Claim Act. There is an incentive for whistleblowers to whistleblow. Part of any settlement goes to the whistleblower, so they get exorbitant compensation. So there's an incentive to report you to the government, is the point I'm making, unfortunately. Okay. Under the anti-kickback, again, I don't expect you guys out there to be lawyers, right? I don't expect you to be lawyers, but I want you to understand these statutes and what the risks are for you waiving, a Medicare coinsurance, for example. Under the anti-kickback statute, it prohibits offering any remuneration to induce a person to purchase or offer a medical service. For example, you tell a doctor, send all of your patients to my laboratory and I'll give you $100 per patient. That's a violation of the anti-kickback statute. So you say to yourself, well, how does this statute get involved with me waiving patient deductibles? If a provider tells a Medicare beneficiary, say, hey, you owe 20%. You don't have secondary coverage. You owe 20% coinsurance every time you come in. But for my practice, I'm going to waive that 20%. So you're giving the Medicare beneficiary an incentive to come to your practice. And it's almost the same if you gave that Medicare beneficiary, in the government's eyes, $100 to come see you. Okay. Again, exorbitant compensation to whistleblowers, criminal and civil penalties. Now, the point here is that these statutes, federal statutes, are serious. Almost every state has some sort of version of those statutes. So when an insurance carrier brings a lawsuit against you for fee forgiveness, usually it's a countersuit, they're going to allege fraud as well. And these are some of the statutes. Here's the New Jersey and the New York statute. So the point being is commercial plans can also sue for common law fraud and for statutory fraud under most state statutes. Now, many of you out there may be looking at this and say, "Oh my God, I'm doing a lot of things wrong." Don't worry. I have compliance keys. How you can be compliant. how you can develop a financial hardship policy to meet your patient's needs. So don't worry, we're gonna cover that. And again, if I don't cover it, you can email the association or me later on, and I'd be happy to either jump on a call or answer any question. So what do commercial plans do when they sue for fee forgiveness? They allege violation of the in-network participating provider agreement. That's breach of contract. Civil liability attaches to the provider. If you're out of network, they frequently allege tortious interference with a contract. We have a contract. Aetna has a contract with its members. It requires the members to pay their coinsurance deductible. You're waiving it, so you're interfering with the contract we have with our member. Civil liability attaches. You could be sued for damages. State fraud statutes, we just covered the New York, New Jersey one. Those involve not only civil liability, money damages, but also criminal liability. And a lot of practices, tell me, well, I'm okay, I have a financial hardship policy. Be aware that simply having a financial hardship policy is not good enough if the financial hardship policy is either vague or not commercially reasonable. I had a client once tell me, when we go into financial hardship, we'll talk more about this. I have a financial hardship policy. It's called an indigency policy. It was drafted by a lawyer, and they told me if everybody signs this, every patient signs this, I can waive all the balances. And I said, I looked at the policy, and I said, the policy states that the patient's acknowledging that they're indigent, and there's criteria, and there has to be supporting documents to support, the fact that they're, basically at the federal poverty level. Your office is in Scottsdale, Arizona. How could you argue that every patient qualifies as indigent? I said, you definitely misunderstood the attorney. This only applies to patients that can establish, being indigent with supporting documents. So be careful of financial hardship policies. It's not a get out of jail free. We'll go over what should be in your financial hardship policy shortly. Courts are concerned with discounts of patient cost share. The problem with discounts is that the courts and the insurance companies argue that you're billing the insurance for a charge that's not your real charge, because you've agreed to waive 20% of it. So if the charge is $10,000, as you'll see soon, we'll have an example, and you agree to waive $2,000 coinsurance, but you're billing the insurance company $10,000, you're committing insurance fraud in the eyes of the insurance company. So routine waiver of patient cost share can be viewed as a breach of contract for in-network providers. We discussed that. And a tortious interference with the member's contract, with the insurance company member's contract, for both in and out of network providers. The reasoning in most of the lawsuits that I've looked at is that uniform discounting or waiver of patient cost share responsibility, that's like that it's a practice of waiving these balances. Again, it's not a one-shot deal. This is a recurring systematic practice of waiving balances. It evidence that the provider is really only intending to collect that portion of the fee which is not discounted. Just like I said, the $8,000, not the $10,000 you're billing to the insurance company. It makes it an improper claim, and it's insurance fraud in the eyes of the government and insurance companies. So we talked about members' contracts with their insurers. My patient has a contract with Aetna. All right. In those contracts, most of them contain language like this. So look at this one insurance policy, the bullet to the left. It says, participating providers agree to accept the eligible charge for covered services. That's the fee schedule. Non-participating providers usually do not accept the fee schedule. Therefore, if you receive services from a non-participating provider, you are responsible for the amount of your co-payment or co-insurance plus any difference between the eligible charge and the provider's actual charge. So what they're saying there is, in this plan, you're responsible not just for the deductible and co-insurance, you're responsible for the balance bill. What's the balance bill? For an out-of-network provider, it's the difference of the charge and everything that's been paid. The way they say it here is the same thing. So, and under this plan, if you're out of network, you have to bill the patient the difference between the charge and everything you collected. That balance, it's called a balance bill amount. This provision is not in most of the plans, but usually there's a provision that says whether you're going to an in-network provider or a non-participating provider, you as the member are responsible to pay your copayment, coinsurance, and deductible. So under this other plan, this is a self-funded plan administered by United Healthcare. It says for out-of-network benefits, you are responsible for paying directly to the out-of-network provider any difference between the amount the provider bills you and the amount the claim administrator will pay you. That's the balance bill amount. More frequently, you see general language that requires the members, whether it's fully insured plan or self-funded plan, to pay their deductible, coinsurance, and copays, and even sometimes non-covered services. Okay, so if you're in network, if you're waiving that balance, you're breaching your in-network contract with the carrier. If you're out of network, you're tortiously interfering with the contract, and you may be breaching the contract anyhow directly based on assignment of benefit. So when you look to litigation, we'll cover some cases. You'll see that based on where, what circuit the cases are in or what court they're in and what state they're in, the courts are inconsistent. Sometimes they say that the insurance company can rightfully withhold payments and seek and obtain a refund of the money they paid when there's evidence of fee forgiveness. And sometimes they say that the insurance company can't, and the insurance company can't withhold payments and they have to pay the claims that they're withholding, and they're not entitled to a refund. It's kind of a crapshoot. So it depends on where you are, what court you are, and the cases in your jurisdiction, unfortunately. So, but we're going to cover some of these. So polling question. Are there any exceptions where a patient's financial responsibility can be waived? Waiving deductibles and coinsurance. Are there any exceptions where you can waive that patient financial responsibility? Yes or no? I'm just going to wait for the moderator to tally up the responses.
We have about 75% saying yes, 25 no.
Okay. Well, I mean, the answer is yes, and we'll for the 25% that got that wrong, you'll see that we didn't cover the exceptions yet, like financial hardship, prompt payment discounts. So we'll cover that going forward. So yeah, as a general rule, you need to bill the patient for their financial responsibility, their copay, deductible, and coinsurance, right? Are there exceptions to that rule where you can waive or discount that? Of course. Of course. The answer is yes. Okay, so let's examine a real life case. This is Horizon Blue Cross of New Jersey versus East Brunswick Surgery Center. They are an out-of-network, non-participating provider ambulatory surgery center. So they're out of network. Horizon sues the out-of-network ASC for routinely waiving patient cost. Again, routinely waiving, not one-off cases. Horizon did, basically how this starts, ladies and gentlemen, is Horizon either gets a whistleblower complaint or they do their own investigation. Sometimes they'll actually send patients questionnaires. I always tell my clients, particularly my clients that we do medical billing for, I say, you tell your patients that if they get anything from an insurance company, either a check, an explanation of benefits, a remittance, a questionnaire, do not fill anything out, bring it to us. We want to look at it first. So in this case, Horizon sent some questionnaires to patients and they asked a simple question. Did East Brunswick Surgery Center bill you for your deductible, coinsurance, and copay? Answer, no. Did East Brunswick Surgery Center tell you that they would accept insurance as payment in full and not bill you for cost share? Answer is yes. So those are the questionnaires. Sometimes they'll simply get they'll send a request, and you have to have your billing company and your revenue people know how to identify these things. If you get a request as a medical provider for 30, 40, 50 charts, 10, 20, 30, 40, 50 charts, that's an audit. You know, you shouldn't just send those in. You should check with a compliance expert, someone like myself, law firm, you know, even reach out to the association, the American Association of Oral and Maxillofacial Surgeons. You know, you have to be careful how to respond to that. So if they're asking for, the carriers are asking in this letter where they want 50 medical records, a lot of times they'll throw in, and we want to get patient statements. We want your patient statements. We want to know how much patients paid you for their cost share responsibility, patient ledgers. You know, that's a fee forgiveness audit. So a lot of times what the carriers do in these audits, they throw out a wide net, and they don't really know what they want to go after you for. So they want the medical record to see if there's maybe any upcoding or downcoding happening. Can they deny claims for retroactively saying claims are not medically necessary because the records don't document the services? Can they find upcoding or downcoding? Are you using modifiers overusing modifiers you shouldn't? And if they can't find anything related to the medical records, they're squeaky clean, then they may say, all right, do we have a fee forgiveness situation on our hands? And the key trigger for that is, are they asking you for records pertaining to patient statements, how much the patients have paid for deductibles and coinsurance? That's a tip-off. So the lawsuit that Horizon files against the out-of-network ambulatory surgery center is insurance fraud, count number 1, common law fraud, count number 2, negligent misrepresentation, count number 3, and tortious interference with Horizon's contract with its members, which require its members to pay their deductible, coinsurance, and copay. And the ambulatory surgery out-of-network center was waiving those balances. All right, so this is a direct lawsuit filed by Horizon. Dealing with exceptions, by the way, one of the exceptions is the OIG safe harbor exception. I'd like to get back to that after I cover it, if it's okay. So let's just skip that and let's stay on Horizon Blue Cross, and I'll go back to that, I promise. So, does it matter, I say at top, if the provider is out of network and has no contract? A lot of clients will tell me, I'm out of network. I can do whatever I want. I have no contract with Horizon. The answer is it doesn't matter in this situation. All right. Horizon alleged that the ambulatory surgery center knew that Horizon's out-of-network benefit design required members to pay co-payments and co-insurance and to meet their deductibles. I'm hoping by now, I've said this multiple times, that these contracts require their members, every single one of them, they require them to pay their cost share. And some of the contracts now, the carriers are more sophisticated. They say, and if you're not paying your cost share, we can deny claims going forward and retroactively deny and take back any money we paid. Okay, they're also doing this in provider contracts as well. They're having this wording. So you got to be careful what you sign. So the answer is no, it doesn't matter if you're in or out of network. These rules apply whether you're in or out of network. So going back to this lawsuit example. So Horizon alleges that the ASC waived patient cost share responsibility, even though they knew that its members are required to pay cost share. And they did this in order to drive patient bodies into their ambulatory surgery center. Because again, if the EBSC center said, hey, you're going to have a $10,000 deductible every time you come in, they're going to be like, no way, I'm going to go to the hospital up the road where I can access my in-network benefits. So the ASC was trying to do pull a fast one here, and think about it. You come to our out-of-network facility, you will have less of a cost share responsibility than if you went to an in-network hospital. If that happens, that formula is a recipe for disaster. So what happened was the ASC was telling patients that they wouldn't be responsible. They double, triple, and quadrupled their patient volume. There was overutilization, something that the carriers are concerned about, as we discussed. And so Horizon alleges that the ASC deliberately overstated its charges in billing Horizon. How did they do that? Well, here's an example, right? They're saying that the claim submitted by the provider, again, the billing company and the in-house billing department is not representing that the claim is accurate and true. The provider is. The more the provider, the surgeon is, the dentist is, the more you're involved in your revenue, the better. It's not a defense that, oh, my billing company is an expert. I don't really know what they're billing. You're representing every time a claim is billed that claim is accurate. So in this scenario, the plan is an 80% UCR, usual, reasonable, and customary plan. There's a 20% coinsurance. So you have a charge of $10,000 being billed to Horizon. The patient pays zero because technically the patient would be responsible for a $2,000 coinsurance, and the out-of-network ambulatory surgery center staff say, you don't have to pay your $2,000 coinsurance. We're waiving it. But I have a $100 coinsurance if I go to the hospital up the road. Well, if you come to us, you'll actually have less of a cost share. You'll have zero cost share. So Horizon in this scenario pays $8,000 based on a charge of $10,000. But Horizon later on, after doing an investigation, determines that the true charge was not $10,000. It was really $8,000. So if the ambulatory surgery center billed $8,000 and put in the remarks on the claim form that they waived the $2,000 coinsurance, they'd probably be better off doing that. I'm not saying they would skate on liability, but they wouldn't be looking at an insurance fraud allegation. All right. So in the eyes of Horizon, and the court agreed, this is insurance fraud. So now let's talk about Medicare, Medicaid, and the other litany of federal healthcare programs. I had made a comment earlier that if you're going to waive your coinsurance or deductible for federal plans like Medicare, you need to be very careful in doing so because the feds take this very seriously. So what does the Office of Inspector General state about this topic? Now, first, I need to tell you, for those that don't know, what is the Office of Inspector General? Well, that is the regulatory body that essentially protects the integrity. It's charged with protecting the integrity of agency programs such as Medicare, Medicaid, and other HHS federal programs. So their job, they're a division or underneath the Fair Trade Commission, and their job is to protect the integrity of the agency programs. And how do they do that? Well, their job is to receive complaints from whistleblowers or the like, investigate complaints, and conduct random audits of medical providers. What are they looking for? They're looking for fraud and abuse relating to bills submitted by a provider relating to a federal health program like Medicare. They're looking for corruption relating to a Medicare or other federal health program. They're looking for criminal activity and conflict of interest. So they do investigations, they conduct audits, but most of the actions you hear about in the news, the big actions and the criminal prosecutions they involve complaints that they receive, usually from whistleblowers. And again, I had mentioned that whistleblowers could be a current or former employee, could be it could be someone from the outside, it could be a competitor. There is an incentive to encourage whistleblowing. All right, so that's what the OIG does. All right, so what does the OIG say about waiving patient cost share responsibility? I mean, deductibles, coinsurance, and co-payments. Well, the Office of the Inspector General states that Medicare's cost share requirement, quote, is an important control on overutilization of items and services. We discussed this ad nauseum in the beginning of the presentation. So that's what they're concerned about, overutilization. If there's overutilization because a cost share responsibility for patients being waived, Medicare is going to pay more money. So a patient may get 20 services as opposed to 2 per month, that they would ordinarily have because they have a $75 deductible each service. So they're concerned with overutilization of items and services. If beneficiaries, and this is from the OIG, quote, if beneficiaries are required to pay for a portion of their care, they will be better healthcare consumers, selecting items or services because they are truly medically needed. Overutilization. The routine waiver of Medicare coinsurance and deductibles can violate federal anti-kickback statutes. We talked about that earlier. If one purpose of the waiver is to generate business payable by a federal healthcare program. So OIG says, yeah, the federal anti-kickback statute that comes with civil and criminal liability could be implicated if a provider is waiving coinsurance and deductibles for a Medicare or other federal healthcare program. Serious business. OIG says a separate statutory provision prohibits offering inducements, including cost share waivers, to a Medicare or Medicaid beneficiary that the offeror knows or should know are likely to influence the beneficiary selection of a particular provider, practitioner, or supplier. Hey, don't go to that provider. They're going to charge you a 20% Medicare coinsurance. I won't charge you that. That's a violation of probably the federal Fraud, False Claim Act, and also the anti-kickback. So according to the OIG, what are the exceptions? In other words, where is it permissible to waive or discount patient balances? And that's where we're getting to. And that was the polling question before. The first exception is financial hardship. And then the second exception is the polling question that we'll get back to. Okay, first exception, financial hardship. Be careful of financial hardship. All right. Like I said, there are many providers that have vague and ambiguous and unreasonable financial hardship policies, and I think it's a get out of jail free. Not true. The OIG says, yeah, true financial hardship can be a reason why you would waive or discount patient financial care. It may be lawful as long as A, the waiver is not offered as part of an advertisement or solicitation. B, the party offering the waiver does not routinely waive coinsurance and deductible. Again, systematic routine waivers, that's what they're looking for. And C, the party waives the coinsurance and deductible amount after determining in good faith that the individual is in true financial need or reasonable collection efforts have failed. So that means is, you're getting documents to support financial need. You have a written financial hardship policy that's reasonable, specific, and not vague, or you sent 3 statements and made an attempt to collect, and at a certain point it becomes bad debt. And if you're going to do that, document. Have copies of your statements. Show efforts to collect the coinsurance deductible. At a certain point, yes, you're not required to put a patient in collections. At a certain point, you can reduce the debt and try to get something instead of nothing. You're not required to sue a patient or put them in collections. So what constitutes a good faith determination of financial need? According to the OIG, the financial need may vary depending on individuals' patient circumstances and several factors including but not limited to. Now, this is the kind of stuff should be in your financial hardship document. The local cost of living is a factor. Patients' income, assets, and expenses have documents to support that. You should get their tax returns. If they're on unemployment, get proof they're on unemployment. The cost of living, patient size, they have 8 kids, where they live, how much money they earn, what's their adjusted gross income for the prior year, this a medical illness, scope and extent of medical bills. All right. The OIG recommends objective criteria. Use financial need guidelines that are based on objective criteria and appropriate for the applicable locality. Make sure the guideline is uniform and not discriminatory. It must apply to everyone, not just Medicare beneficiaries, but commercial beneficiaries as well. Document. Get supporting documents. That's what's required. Flexibility, not inflated income guidelines. The OIG recognizes that the provider can have a good deal of flexibility in making these decisions, but cautions against inflated income guidelines for patients not in genuine financial need. I had another client who said anyone that earns $200,000 as a family gets an 85% discount. It's not reasonable. It's just not reasonable. Okay, now we're going to go back to the polling question, right? Second exception. So the first one was financial hardship. If you have a true financial hardship, you can waive a discount financial hardship. As a subset of that, at some point, if you make attempts that are documented to collect the debt, it becomes bad debt and you can waive or discount. So the second exception is OIG safe harbor exception. It only relates to inpatient hospital services, so I won't cover it very often. I mean, it doesn't really apply to the surgeons that we're presenting to today. But just so you know, compliance with safe harbor regulations is voluntary, and failure to comply does not mean that the arrangement is illegal. All right, but here's the exception. So it relates to inpatient hospital service only. The safe harbor exception permits waiver of coinsurance deductibles for inpatient hospital services for which Medicare pays under the prospective payment system if the hospital meets three conditions. One, the hospital cannot claim the waived amount as a bad debt, or otherwise shift the burden to Medicare, Medicaid, payer, or individuals. The waiver must be made without regard to reason of admission, length of stay, diagnostic related groups, and the waiver may not be part of a price reduction agreement between the hospital and the third party. What is a prospective payment program? A method of reimbursement in which Medicare payment is made based on a fixed, predetermined rate for the certain service for patients with certain diagnosis. You're going to get $100 every time you do this service for patients with this diagnosis. Problem with those programs are if the provider knows that I'm only going to get $100, a lot of times they'll make decisions to cut costs at the expense of the patient. So, you know, you have to be careful if you agree to a prospective payment program. So this is a very limited exception. So again, back to the polling question. Under the OIG safe harbor, which of the following criteria must be satisfied to allow a waiver of coinsurance deductible for inpatient hospital services for Medicare claims? One, the hospital cannot claim the waiver amount as a bad debt or otherwise shift the burden to Medicare or its beneficiaries. Two, the waiver must be made without regard to reason of admission, length of stay, diagnostic related group, etc. The waiver may, the waiver may not be part of a price reduction agreement between the hospital and a third-party payer, other than a Medicare Select program, or all of the above. So I'm just going to wait for the moderator to tell me when he has 75% of the audience answering questions.
And almost all of our responses are D, all of the above.
Correct. We just covered that. Thank you so much. All right. Again, this is a limited exception. May not apply to you. The exceptions that you should be concerned about, and it'll affect all of your practices, is right here. Financial hardship. Right? That's a big one. You don't have a financial hardship policy, you need to create one. And it's not difficult. All right. First of all, you can probably get some online. But these are the factors essentially. And you have to get supporting documents. You have to document it. Not a bad idea to have like a committee at your practice where like every Friday you go through these financial requests, and you have to make sure it's objective, non-discriminatory, and you have to have supporting documents and document. That's really the key. It's okay for an insurance carrier or even the OIG to disagree with the granting of financial hardship. That's not terrible. But not having an objective financial hardship policy with supporting documents that's documented is a no-no. It's okay if they disagree with you sometimes. And again, you have to have flexibility, but you can't have inflated income guidelines that qualify for discounts. Let's talk about professional courtesy. My suggestion is that everybody have a professional courtesy policy. So again, this is if you get audited, right? So what is professional courtesy? Almost every practice does it. Your office manager's sister comes in for a treatment. You don't want to bill that person, cost share, a deductible co-insurance. Or one of the doctors in your practice does has a procedure, and you want to waive the deductible and co-insurance for that person. It has to be limited in scope. Your professional courtesy policy shouldn't be such that 50% of your patients get a courtesy discount. It should be in writing. It should be documented. And you should note that OIG and HHS have emphasized that physicians forgiving financial obligations for reasons other than genuine financial hardship and without good faith attempts to collect those obligations may violate the anti-kickback statute. So these practices risk running afoul of the anti-kickback statute, False Claim Act, and state fraud laws. So my suggestion would be have a written policy, make sure that any discount or courtesy waiver is documented and supported based on the policy, which is non-discriminatory and very narrow in scope. So we talked about financial hardship discounts or waiver of patient cost share. We talked about professional courtesy, which every practice at some point has to deal with. We talked about the safe harbor that only relates to inpatient at hospitals. So I don't think that's going to really be an exception. It's going to apply most of the time. But financial hardship, professional courtesy, two big ones. Prompt payment discounts. And this one it depends on the jurisdiction you're in. I personally don't like these policies. Providers have gotten in trouble. Most of my clients, I tell them not to have one of these. But you'll see there are cases where prompt pay discounts are okay, as long as the discounts are reasonable. I mean, you shouldn't have a discount for prompt payment more than 5 or 10% of reduction of the cost share. So prompt pay discounts, and that's like, hey, if you pay us your cost share within 10 days of the treatment, you'll get a 5% discount on your cost share. Again, those policies need to be in writing. They can't be discriminatory. They have to be posted. All of your policies should be posted on your website and in your office so patients can easily see them. According to the OIG, these policies cannot be offered to induce patients to receive other services. We talked about that. They cannot be offered to induce patient referrals. State laws may prohibit discounting patient cost share. So in some jurisdictions like Idaho, it makes it unlawful to have a prompt payment discount program. Offering cost share discounts may violate in-network contracts. You need to look at your contracts. They may subject an out-of-network provider to a claim of tortious interference with a contract. And again, the Office of Inspector General has said prompt payment discounts are permitted if the amount of the discount relates to the cost the practice would incur to collect the amount. The discount is offered to all patients for all services and items, regardless of their diagnosis, length of stay, treatment, etc. But the discount should be related to the cost the practice would incur to collect the amount, and it should be documented. What is the cost it would cost you to collect that amount? Maybe you're paying a third of contingency to a collection agency, and so you're going to give a third discount. As long as it relates to the cost the practice would incur to collect and it's documented, you should be okay. Personally, I don't recommend more than 5 or 10% discount. I think you're looking for trouble. So I want to talk about some cases. We got about another almost 15 minutes, and then I'll open it up for questions. I think cases are important because they help understand in real life situations how these issues that we're discussing come about. So in this instance, my little note on top is that for in and out of network providers, health plan contracts may allow the administrator to deny the entire claim, even retroactively. We don't have to pay going forward, and we're gonna do a take back, a refund on all the claims retroactively. So if a fee is improperly forgiven by a provider, they could retroactively deny and take back and deny claims on a going forward basis. And here's an example of it. Providers sued for $5.6 million of claims denied by Cigna due to fee forgiveness. Folks, Cigna is extremely aggressive in fee forgiveness audits, probably the most aggressive. They send questionnaires to patients. They're not afraid to file lawsuits or countersuits. So be careful when you have a Cigna patient that you're waiving fees. In any event, so the provider says, "Hey, Cigna, you're not paying my claims. You owe us $5.6 million in gross charges." Cigna says, "We did an audit, and we don't owe you that money. And in fact, any money we did pay you, we're entitled to that money back because our contract with our member gave us sole discretion to refuse to pay for services if Cigna determined that a provider was engaging in fee forgiveness. So in the exercising of that discretion, Cigna claims they have a right to require proof that the patient not only was billed and there was a good faith effort to collect the cost share, but that it was actually collected. So if the provider didn't collect more than like 5% of the cost share, that's evidence that they didn't make a good faith effort to collect. And the court sided with Cigna. Provider's complaint for $5.6 million was dismissed. I'm assuming that Cigna and the provider settled Cigna's claim for a refund for the money for the claims that they actually did pay. There's no evidence that happened, but I'm sure, knowing Cigna, that they put the provider on a payment review and requested money back on the claims they actually paid. So here's a real live example. This North Cyprus case, on the other hand, is a good case for providers. Again, these are out-of-network. Most of the lawsuits arise from out-of-network providers. In-network providers don't fall under the trap that, oh, I'm in-network, I'm okay. We talked about that. You're not okay if these rules apply to in-network waivers of in-network cost share as well. But anyhow, this case basically talks about making sure that you disclose what you're doing to the carrier. So in this case, the center had a prompt pay discount policy, but it was adequately disclosed to Aetna. And so in other words, according to the court, Aetna knew that this prompt pay discount policy was in effect. Aetna sued under misrepresentation and fraud. They sued for $225 million. North Cyprus Medical Center was like, it was a large out-of-network hospital, I believe in Arizona. So, the court held that the insurer could not establish its claim for fraud arising out of the hospital's practice of discounting its patients' non-covered costs if the costs were paid promptly. The insurer could not have justifiably relied on any representation because the insurer's own investigation and its sophistication with its audit department, the insurer knew the exact information it alleged that the hospital did not disclose. They knew that the rates were being discounted. It was being disclosed. So some of the things that I think are interesting. So I'm sorry, this is Texas. And this is federal court. So Aetna sues for common law fraud, healthcare fraud, misrepresentation for over 44,000 claims. The allegations were they were suing the provider for $225 million in damages. Big bucks. So there was a 3-week trial in 2016, and it concluded, and the medical practice won and Aetna lost. The trial, just to give you an idea, when I say the provider won, They didn't really win because it probably cost them $1 million to litigate this case, to defend themselves. The hearing involved 9 witnesses, a review of over 600 trial exhibits, and just to give you an idea of the facility, they were a 175-bed physician-owned general acute care hospital. They marketed themselves as an upscale, patient-friendly healthcare environment. There was a doctor, Dr. Robert Baer, that owned it. They're not a small entity. This is not like an ASC. He grew the entity to $2 billion in revenues, and they had 1.2 million square feet on 60 acres of land on 4 separate campuses. So it's a big organization. All right. So I love cases like this because I always cite them on in my appeal letters. The court basically ripped Aetna. They said there's not a scintilla of evidence that North Cyprus committed fraud. North Cyprus prompt pay discount policy does not violate any federal or state laws and was fully and properly disclosed to Aetna. That's the key. Aetna's claiming that they didn't disclose, but they knew that this policy was in effect and that Aetna members were getting discounts based on it. North Cyprus violated no state or federal laws with regard to any business practice. Aetna suffered no losses or damages with regard to the 44,000 plus healthcare claims submitted by North Cyprus to Aetna over a 4-year period. All of Aetna's claims were dismissed by the court with prejudice. The court said, after an all-out specious legal assault by Aetna against our 10-year-old general acute care hospital, this is from North Cyprus, the court has affirmed what we all knew, that we didn't violate any federal or state laws. And the owner, Dr. Baer, concludes, and I see this all the time. He kind of says, Aetna's the gorilla in the room. They're bullies. Their SIU department was bullying us because they wanted us to pay money. First of all, they didn't want to pay $225 million in claims, and they wanted money back on the back end. And I can tell you, having handled many of these SIU investigations, they do sometimes, their SIU departments act like bullies. And there are many former FBI agents and law enforcement officers that work, and it's an intimidating process. So anyhow, what Dr. Baer says is this was a classic case of overreaching and corporate bullying by a national insurance company intent on forcing healthcare providers to bend to its money-grabbing tactics, disallowing charges, inventing new rules suddenly, and moving the goalposts regularly on us. On behalf of our patients, payers, and talented medical staff, North Cyprus refused to comply with Aetna's unethical demands, and we aggressively and successfully defended our management practices and quality healthcare delivery principles. Now, they also had to spend a fortune on experts. I mean, it was a win, but not really. They easily spent over $1 million. Now, Aetna, they can afford. They made. I think last year, United Healthcare posted, when a lot of practices went out of business with COVID, they posted a $22 billion with a B profit. So they can afford to do this, but most practitioners can't. Here's another case. This case involves a healthcare provider advising Cigna that its billing practice was structured to mirror in-network rates. I see this all the time. We're not going to bill the out-of-network cost share. We're going to bill the in-network cost share. That's fee forgiveness, ladies and gentlemen. That's fee forgiveness. If the in-network cost share is $100 and the out-of-network cost share is $5,000, and you're billing the patient an in-network cost share of $100, you're fee forgiving $4,900. So in this case, Crescent City Surgical Center versus Cigna, Cigna stopped making payments to the plaintiff healthcare provider due to alleged fee forgiveness. Plaintiff sued for breach of contract, and Cigna countersued for fee forgiveness. The provider billed patients the cost share for which they would be responsible for in-network. The provider lost. There was a settlement. Cigna probably got a significant settlement based on fee forgiveness here. A couple other cases. We got like another 10 minutes, 8 to 10 minutes. Quickly, Connecticut General case. Cigna sued this out-of-network provider for $4 million alleging that it unlawfully engaged in fee forgiveness practices that excused Cigna's obligation to pay for services provided. So Cigna said, you're waiving your fee forgiving. I don't have to pay for your claims. Cigna asserted claims for recoupment of these overpayments. They viewed all payments they made where there was fee forgiveness practices. They viewed them as overpayments, insurance fraud, negligent misrepresentation, and they sued for legal theories such as promissory estoppel, fraud, violations of the Illinois Consumer Fraud Act. The court found enough evidence of improper fee forgiveness to allow the claims to go to trial. So unlike the North Cyprus case, this court said that there's enough evidence of fraud to go to trial. Likely there was a settlement and Cigna probably recovered a substantial amount of money from Southwest Surgery Center, I would think. Here's a couple other cases. Almont Ambulatory Surgery Center versus United. United refused to pay for lap band procedures, resisting the health plan's counterclaims based on improper fee forgiveness. The provider argued that they made no misrepresentations by failing to disclose waiver of copayments because the industry standard billing forms contained no spaces for disclosure. In other words, we would have provided disclosure to United Healthcare, but when billing the claims, there's nowhere where they could have disclosed that they were waiving balances. There really is. There's a remarks code on the claim form that they could have said, patients getting financial hardship waivers or something like that. Or they could have sent a letter after the claims were sent. But anyhow, the provider said that they followed standard industry practices by simply noting their total charges on the billing forms, making no representations one way or the other that they would collect copay obligations. Providers also noted that they did not know the amounts of relevant copays until they had submitted the claims and received the EOBs, which really is true. But like United points out, aren't you doing a verification of benefits? When you do a verification of benefits, aren't you checking what the deductibles are and how much has been satisfied and what the out-of-pocket max is and what the coinsurance is? So the provider was being a little disingenuous here. Provider said that they followed industry standard by simply noting their charges on the claim form, making no representations as to whether they would collect copay obligations. They said they didn't have to. United countered with arguments that since the provider routinely verified with United the amounts that the patient had to satisfy for deductibles, what I just said, there is evidence that the provider could have but did not seek and require payments by the patients of deductible amounts either before providing services or after services, but before billing United for these services. So United contended that it did not matter if a provider cannot calculate the exact copay or deductible at the time of billing, because what the provider cannot do is submit a claim form with charges that include the member responsibility that the provider already waived. Charge is $10,000, we waived $2,000, we should be billing for $8,000, not $10,000. So that case probably resulted in a settlement, and most of these cases are not good for the provider. That's why I like the North Cyprus case, because it's pretty good. 5 more minutes. Let's see how many more of these cases we can get through. Another Cigna case. Cigna alleges that patients signed patient statement forms declaring they could face financial hardship if required to pay. So in this case, all patients that came in signed financial hardship. You know yourself, it doesn't make sense that every patient would be under a financial hardship. So Cigna maintained that the provider's fee forgiveness practices were impermissible under the benefit provisions of their health plans, which required members to pay their cost share responsibility. The plans excluded bill charges, which the member was not obligated to pay for which the member was not billed, and the case settled. So again, you have to understand that the members' contracts and some of your in-network contracts, the members, for the most part, are agreeing contractually to pay their deductible and coinsurance. If you're waiving it, you're interfering with the contract that the member has with their insurance company. And if you're in-network, you're breaching your in-network contract. These cases are basically giving more examples of what I've been saying all along. All right. Another case, this is from a whistleblower. He was a call center rep in which the provider was accused of unlawful co-payment and deductible waiver and forgiveness. So in this case, the provider allegedly billed for glucose meters that it knew were likely to be disallowed and not covered by Medicare. All right. The provider then would write off most or all of the patient liability for the glucose meters when Medicare denied the payment, which is a patient inducement, arguably a kickback, so that they can get the patient to agree to other supplies that they can get covered. The court denied the provider's motion to dismiss. Arriva Medical agreed to pay $160 million to settle their claims with the government. Wow.
And
So
Tom,
let's
I
talk
want to
about.
jump in. We do only have a couple of minutes left, and we want to
Okay.
ask a couple of questions here.
Sure, go ahead.
All right. So first question we have, if we have an agreement with a charitable organization to provide OMS services to their dental patients, do we have to get documentation of financial hardship if they're vetting the patient's need before they refer to us?
I need to see that contract. It's impossible to answer that question without seeing the contract that you have with the charitable organization. So I think any attorney would have to see that contract and see what we agreed to. There is no exception that I'm aware of for nonprofits or charitable organizations, but I would have to see that contract. I'm so sorry, I really can't answer that question. But if you email the question to the association or to me, I promise to get you an answer to that. Is there another question?
Yep. Next one, can we decide not to charge a patient for a service? For example, a bone graft, we do it, but we don't charge for it.
If you're not billing the insurance company or to Medicare, and because you know it's not covered, then if it's a non-Medicare claim, you can bill the patient a self-pay charge for it. But yeah, you don't have to bill the patient. If you're not billing insurance, you don't have to bill the patient. There are exceptions, like surprise bill law would be one, federal surprise bill law, so I'd have to see the scenario. But generally, if you're not billing, also think about the risk. If you're not billing Medicare or a federal government health program, and you're not billing an insurance company, you're not committing insurance fraud. So if you know it's not covered, remember that case we talked about, the glucose meters? They knew it wasn't covered and they billed Medicare. That was the problem. They knew it wasn't covered and they billed for it. So no, yeah, you don't have to bill the patient for something that's not covered. I would document in a chart why you're not billing, or you can charge the patient a self-pay discounted fee for that. That's not really fee forgiving. I hope that answers that question.
Thank you very much. Unfortunately, we've run out of time for today's program. This concludes today's program. This webinar has been approved for 1.5 hours of continuing education credit. A certificate of continuing education will be available upon completion of the course evaluation and assessment. To claim your certificate of continuing education, please return to the program page. If your office requires additional CE certifications, please email a list of participants and the original registrant's name to ceonline@ams.org. On behalf of the American Association of Oral and Maxillofacial Surgeons, I would like to thank you for your participation in today's event. Thank you and have a great day.